Hello there, good evening. Welcome to the Jim Bohannon Show from Westwood One Radio. We're at 1-866-50-JIMBO, 1-866-505-4626. Online, you'll find us at jimbotalk.net, and you can follow me on Twitter at JimboTalks. President Trump is again unhappy with a federal judge, this time after he issued an executive order to cut funding to sanctuary cities, and a federal judge says, no, you can't do that. Here's Kristen Holmes.
President Trump attacking the judicial system after a federal district judge blocked another one of his executive actions on immigration.
We'll see him in the Supreme Court.
A San Francisco judge ruling against an executive order that attempted to strip federal funding from cities that do not cooperate with immigration enforcement, otherwise known as sanctuary cities. The president taking to Twitter to accuse the system of, quote, judge shopping. In other words, choosing liberal judges to hear his court cases. Then saying he would see the case all the way to the Supreme Court. This after the White House issued a statement railing against the court's ruling, calling it an egregious overreach and saying officials in sanctuary cities have the blood of dead Americans on their hands. But others celebrated the court's ruling, including the mayor of Los Angeles, a sanctuary city.
It's a great day for our Constitution. I think it showed that unconstitutional political threats against our cities cannot take away our rights, and they certainly can't steal our tax dollars.
Tuesday night, White House Chief of Staff Reince Priebus saying the federal court was going bananas and saying the administration was taking steps to appeal that ruling. In Washington, I'm Kristen Holmes.
Let's talk about that in this portion of the program with Eric Cedillo, the founder of the law offices of Eric Cedillo PC, and CEDILLO law.com, his website. Good evening.
Good evening. Thank you for having me on.
Absolutely. Good to have you on this evening. You practice law with offices in Dallas and San Antonio, and also are an adjunct faculty member at Southern Methodist University's School of Law. Your take on the back and forth over these executive orders thus far?
Well, specifically with respect to immigration, I think Judge Orrick was right on in determining that what Trump had done or the administration had done was right on with respect to the Constitution. Basically an injunction. He enjoined or stopped the president from implementing the ban on funding to what are purportedly sanctuary cities and counties and localities around the country. So he's right in terms of what he did.
Well, purportedly, I mean, they're very proudly, defiantly in the category of sanctuary cities. That's what they're doing. I just was wondering if we all get to pick a federal law that we don't like that we can ignore.
Well, quite honestly, the distinctions that are made between what the federal government can do and making states and localities do what they're supposed to do, they don't have to abide or...
No, they don't have to get federal money either. That's no right.
Well, from what the judge was saying is you can't necessarily coerce, the federal government can't coerce these localities into doing this either based on, the 10th Amendment to the Constitution. So it's a situation where you can't force the localities to do the bidding of the federal government.
Nonetheless, I mean, I can certainly be forced to obey any number of federal laws, be it laws against transporting minors across a state line or bank robbery or what have you. Again, we get down to the notion of just who among us is allowed to ignore which federal laws. And if sanctuary cities get to ignore them, then I'd like my shot at picking a federal law I get to ignore also.
Well, it's actually not ignoring the law. It's the actual conducting the law or being forced to do the job of the federal government. And that's the distinction that is made. Of course, there are criminal and penal laws and other laws from the federal government that you have to certainly abide. But with this, specifically with the sanctuary cities aren't clearly defined, but it kind of originated from the ICE detainers which were issued. They're basically voluntary in nature in terms of they're civil, they're not criminal, and they're things that are voluntarily accepted by localities in implementation. So the government understands that, and because of that, and based on the 10th Amendment, they can't force it. So what Donald Trump has done with his executive authority is kind of attempted to supersede that, and that's where he gets into constitutional problems.
So you're saying what, the government has no power to enforce the laws regarding immigration into this country?
Oh, absolutely not. That's not what I'm saying. What I'm saying is that the federal government can't force states and then thereby municipalities and localities to do the bidding of the federal government in the implementation of immigration law. They can't conscript them to do the bidding of the federal government based on the 10th Amendment.
On the other hand, again, I fail to see where the states or localities are quote, losing their rights over this federal aid. If they don't wish to be a part of the United States government in this regard, then they don't have to be spending all those federal education or highway dollars.
Right. Well, specifically, there are different parts of what the problem with this particular executive order is. It doesn't clearly define what sanctuary jurisdictions are or what it is they're doing. If you're talking specifically about requiring that localities, let's say a local jail, were to adhere to an ICE detainer, be forced by the federal government to adhere to an ICE detainer, that would be unconstitutional. You can't make them do these things. The federal government can't make them do these things. That's why they do them based on a voluntary basis. And most of them agree to do them. What the sanctuary cities or the split was happening was with some of the sheriffs or constables or whoever's running the jail basically said, hey, look, we're getting sued for these things based on, the fact that these are civil detainers and not penal or criminal detainers issued to us, and there's been no vetting. There's been no magistrate or judge who's issued these orders. So how can we hold these people longer than, once they make bail, we're holding on to them and telling them that we have to wait for ICE to come pick you up? So that is where it gets into a situation where the federal government, through this executive action, basically holding monies to say you must do this, it's coercing them in such a way that it's forcing them to do the job of the federal government specifically for that purpose.
What about, let's say, people who are not only here illegally in violation of our immigration laws, but who have maybe perhaps broken, a real law, like stealing something or rape or what have you? Does that also get covered by this? Is this absolute, the power of localities and states to ignore the law of the land?
No, absolutely not. Those aren't. There can't be an ignoring of the law. Certainly, if there is a crime that has been committed, that's the distinction. That's the difference. The penal nature, the criminal cases that you have are different from the issuance of a civil ICE detainer. That's where the distinction is made.
So if you break a federal law, I mean, it's not a criminal law, it's not really breaking the law. I find that a most remarkable distinction. Seriously, I granted I'm not a lawyer, but I find that an amazing distinction.
Well, it's not necessarily. It's specific to that particular area. The federal government issuing an ICE detainer, basically a civil warrant, which says hold these people until we come pick them up. Now, if this was a penal situation or a criminal contention, then a criminal detainer would issue and they would have every right to hold them and do what they're doing. The distinction is that these are civil detainers and that they're not criminal. So again, the federal government can't coerce localities to adhere or do or conscript them to do what the federal government is doing or what they should be doing. It's why it's so voluntary. It's why sheriffs can say, we're not going to partake of that particular governmental function that the federal government wants us to do. And usually the federal government is fine with that. But what Trump has done is he's gone and exceeded that to the extent that he's told them that if you don't do this, we're going to take away your funding after the fact, after, situations wherein they've already made agreements to do certain things.
So if you break a law that is not, quote, a criminalized law, it's not really a law? I mean, wouldn't this whole thing just be settled very simply by repassing violations of immigration law to attach a criminal penalty to it? Wouldn't that put an end to this?
Well, I think what we're saying with respect to what purportedly sanctuary cities are doing, you've got to look at everything in context of what it is you're asserting they're not doing or they are doing.
They're not cooperating with the law of the land. I know that.
Specifically with respect to these detainers, they don't have to. Quite honestly, that's the difference.
But I'm saying that if these laws were repassed to include a criminal penalty, then presumably the immigration laws would no longer be civil laws, but they would be criminal laws, would they not? In other words, if some kind of prison term were passed in connection with this, would that not change the category?
Well, it could if the federal government said that these were specifically laws, but then you would get into Fourth Amendment protections and Fifth Amendment protections. You'd have a magistrate or judge determine that due process was availed itself and that there was enough information to actually issue a criminal detainer in some way, absolutely. And that's what we have in terms of our criminal detainers. But again, the distinction is to be made that these are civil detainers, that they're not criminal. They haven't been vetted by a judge or a magistrate, and that's the distinction.
You talk about a Fourth Amendment violation, the right of people to be secure in their persons, et cetera, and so on.
Right.
How would that differ from, let's say, somebody who just robbed a bank? Again, I'm trying to understand the distinction here because we all know what's going on. There are some people out there who want open borders for this country, but they haven't got the guts to come forward and actually say so, and so they play these little games. And that's what's going on here. So I'm just trying to understand what kind of gymnastics Congress would have to go through to actually enforce this law.
They would need to amend the Constitution.
Why? What part of the Constitution would they have to amend?
Probably the 10th Amendment.
Well, now, I'll read that. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people, which is interesting. Usually that's cited by conservatives, but this seems to be one where liberals have hopped all over that. What particular power not delegated to the United States by the Constitution is involved here? Because certainly the power to determine immigration is in here under the powers of Congress.
No doubt. I think the Supreme Court has determined that what the federal government cannot do is force the states to do their bidding in terms of things that are specifically reserved to them. That is what has been interpreted to the 10th Amendment to mean, that they can't force them to do these things, and that would be something that would be violative. And specifically, again, there are other areas in which we may be talking about something different. If there was a true situation where cities or localities were trying to protect individuals from being deported, that would be different. What's happening here is with respect to the detainers, the ICE detainers. That is the distinction to be made or had. It was the original, I think, the impetus for what they considered sanctuary cities to be. Now, that's been expanded upon in a lot of different ways and in a lot of different areas. But specifically with respect to this, there's just a big difference between, civil and criminal detainers.
Let's tell you what, we're going to take a break. When we come back, I will take a look at the 10th Amendment as we have cited it and the powers of Congress under Article 1, Section 8 to see if, in fact, we're talking about powers not delegated to the United States by the Constitution. We'll be back with our guest, Eric Cedillo of the law firm Eric Cedillo, PC, and back in just a moment. Welcome back to the Jim Bohannon Show, and we'll take a call here, just a second here, for Eric Cedillo of CedilloLaw.com. But before we do, noting the provisions of the Constitution you've cited, the 10th Amendment, the power is not delegated to the United States by the Constitution, nor prohibited to it by the states, or reserved to the states respectively or to the people. Okay, under powers delegated to the United States by the Constitution, Article 1, Section 8. The Congress shall have the power to establish uniform rules of naturalization, regulate commerce with foreign nations, and provide for the common defense and general welfare of the United States. That seems pretty specific to me.
Right.
You would, disagree that specifically is a power reserved to the United States?
No, absolutely. I do agree with that. I do agree with that.
So why then would the 10th Amendment apply here, if this is in fact an area that is the fair jurisdiction of the federal government? Right.
The 10th Amendment, there's no doubt that the federal government has the right to regulate immigration. There is no doubt that the federal government most likely has the right to enter into jail facilities, localities, and others to pick up people they believe who are in fact deportable. There's no doubt about that. What the 10th Amendment has done, what the Supreme Court has determined, and I'll just read from Judge Orrick's ruling in terms of the case law that he cites for the Supreme Court. The federal government may not compel the states to enact or administer a federal regulatory program at New York 505 U.S. at 188. The federal government may neither issue directives requiring the states to address particular problems nor command the states, officers, or those of their political subdivisions to administer or enforce a federal regulatory program at 521 U.S. 898. This is true whether Congress directly commands a state to regulate or indirectly coerces a state to adopt a federal regulatory system as its own. So what the 10th Amendment does is it says, absolutely, the reservation is with the federal government in terms of the implementation of immigration law. What you can't do, federal government, is force these localities to assist you necessarily with the administration of that immigration law.
Well, we'll
that
see.
That is why these ICE detainers are voluntary in nature.
Well, we'll see how the Supreme Court rules when it gets to that, and obviously it will. To Charlotte in Durham, North Carolina. Welcome.
Thank you very, very much. I'm so grateful for this show and for your integrity. But, Jim, no disrespect intended, because let me just tell you one thing, dear. I have very, very limited knowledge of the law, but it seems to me that this gentleman just got through speaking in a very convoluted way. Indeed, the federal government does have the authority to enforce its laws.
No, I don't. Well, he is not arguing that the federal government has the authority to enforce his laws. He's arguing that there's no obligation on the part of states and localities to help them enforce it.
I fail to see that, and I have attorney friends.
Let our guest respond to that then.
No, you're absolutely right. There is no doubt the federal government. It's one of the reasons why the federal government cannot specifically tell states that they must assist with the implementation of immigration regulations and other things. That is the point. In doing that, enforcing them, and what the directive or the executive action by Donald Trump was, or what it did was, it basically tells these localities that we are going to pull funding, which this court particular said was coercive in nature, and force them or compelled them to conscript to assisting them with immigration, which they cannot do.
They're free to, of course, turn down that federal money if they so wish.
You're right. You're right. They could. They could turn down those monies, and that was the situation where the Fifth Amendment came into play as well with respect to the Due Process Clause, and what the court determined with respect to that. Also, if the Congress were to create a law that mandated something like this, it may be violative of the 10th Amendment, but then would have issue with respect to the timing with which it was implemented. So if you've got to actually give them an opportunity, treat this like a contract between the states and the localities, make this determination. If you want these monies, then dealing with if the federal government sets it out and says, if you want these monies, here are the conditions, that would be different. That would be a different situation.
All right. We may have time for a quick call from Bruce in Essex, Massachusetts. Hello.
Jim, I'd like to hear a discussion of Article 6 of the Constitution, where it says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. I'd like to hear a discussion of that.
Well, all right. We've got about 17 seconds here, Mr. Cedillo.
Well, yeah, that's the Constitution. That's the creation of what it is. That is, the Constitution is the supreme law of the land, and we must all adhere to it at every level of government, the judiciary, the states, the localities, everything and everyone must adhere to the supreme law of the land.
Briefly, unfortunately, we literally meant briefly, I regret to say, this is Westwood One.